So the main thing we're talking about today is, are you ready to die? And there's a lot of aspects to that. And there's a couple of goals as to why we do these seminars, if you've not been with our seminars before. One is to dispel myths. People hear a lot of different things, or events occur to other people, and you're turning around going, okay, how does that relate, and is that true or not true? So the problem becomes that we do hear a lot of things. There are a lot of things out there, and unique things happen to some people, which may have been something that's completely out of the ordinary, and it may be very common, such as the credit cards. So we'll cover some of those to dispel some of those myths. The second is to give you information to help yourself, help your family, help your friends. There is a lot of different tools with estate planning. There's a lot of different things you can do to be prepared to die, but they don't all relate to you. It may not be your situation. So as you're going through this, listen for who might benefit from that information. For instance, on the issue of the credit card, that person, you actually as a husband and wife need to have 2 different credit cards with each spouse as a different primary person on there, because only the social security number of the primary card holder is getting any kind of a credit rating. And so that's why when one dies, they go to close down credit cards, automatic withdrawals, then you try to figure out if you have any credit rating, and they go, well, you've never had credit. I didn't sign in this credit card for 30 years, but it wasn't your social security number. So you want to make sure that some of the things we talked about today, if they don't relate to you, is there someone you could pass this information along to? And even if you want, you know someone that was going to be here today and couldn't, you can always ask for another set of the slides that can give that to you, and eventually it'll be on our website anyway. The third is to be a resource. Many of you are clients, I recognize. Many of your clients have other attorneys with us. And as you know, we do have a monthly newsletter that comes out. We have an annual one, usually in print. We're available for phone calls and emails. We do everything we can to teach. We have multiple other seminars on our website. We have resources available as well. So be a resource. One of the things for our clients, you know, is our post-death letter. And one of the biggest things you hear people say when someone dies is, I don't know where to start. So part of what we have is a 3-part letter that goes out of now 4 pages of the most common organizations or institutions that might need a phone call when someone dies. How do you order more death certificates? What do you do with a handicap parking permit? What if there's veterans benefits? It just goes down 4 pages of check the box. Well, enough of our clients kept asking for that in print that it's now in your notebook. So if you have a friend who's lost a loved one and you hear them say, I don't know where to start, give them a copy of it. So a lot of the material that we cover, if it doesn't relate specifically to you, think about who it might relate to, and feel free to pass it on. This is all stuff you're more than welcome to pass on, okay? So slide page 2, please.
When did it go in the notebook?
We had it for about 5 years. It's under a tab called, where's your notebook? Things to do in a death curse. This one will have it. I can tell by the front of it. It's right here, this one right here, things to do when a death occurs. It's a good, we've had so many people that passes it on, because people always think I could Google what to do when a death occurs. Yeah, you'll be reading till you're 150. So just having something concise, and no, it doesn't cover everything, but it has been put together by our clients as they've been settling estates, and we've been working with them to settle estates. So it's a really good one. I don't exactly remember what year we first put it in there, but it's been several because people kept asking. So it works out well. Okay, so are you prepared to die, and how do you get prepared will be topic number 1. Topic number 2 is what tools are available to you. Because estate planning, if you've worked with us or have done research on estate planning is just a series of tools. I compare it to a gardener. Now, I'm amateur, but when we bought our latest house, we had a driveway that was a little bit longer than this room. And from here to that back wall on the side was all junipers, okay? Does anybody here like junipers? Because I want to apologize ahead of time. I grew up all boy. I grew up outside barefoot. I grew up with my mom with a safety pin picking juniper spurs out of the bottom of my feet. It was years later I learned that a straight pin is smaller than a safety pin. Mom! Okay. So when we moved in, both standing, I looked down and went, that is so not happening. But if you go to take out junipers, you do not use this little spoon of a shovel, okay? Backhoe, come along, chainsaw, pickaxe, dump truck, neighbors who will never talk to you again. Those are the kind of things you need to remove it. But then when you go to plant in that garden, you do need the little shovel. You do need the tools, the right tool for the right job. And estate planning is that way. So even in preparing to die, there are appropriate tools depending on your circumstance of what would work best for you. So that's a bit of what we'll look at. So, slide 3, good question. How do I prepare to die? And there is a very interesting by John. Life is what happens to you while you're busy making other plans. Absolutely. Absolutely. That is so true. And for those of you who know our family right now, that's 100% true. And those who've had other medical things and situations that have come up, you have your plans and then life happens. And getting prepared for that will very much help. So are there things that if an emergency occurs that you need to do right now? Can you do them really, really quickly? Well, yes, and they're like a Band-Aid. But many of these are very, very important. One of the questions that someone asked was the issue of community property. One of the things you can do is called a community property agreement between a husband and wife. But please understand, like all tools, there's good uses and bad uses. A good use of a community property agreement is between a husband and wife, where if they die, they want their wife to have everything outright, 100%. No protections, no control, it is all yours. If that's your situation and you're not worried about the survivor's car accidents, you're not worried about the survivor remarrying and giving it away, you're not worried about estate taxes, you're also not worried about the future beneficiaries, it's an amazing tool. For some people taking off on a quick trip, it's a good resolution. But please understand what community property is in the state of Washington. There's about 9.5 states. Ladies, how many of you can hold up an original wedding ring? Okay, so this is the original. When did he give it to you? Except you, she. When did they give it to you?
When you got married.
Ah, okay, yes you did. When you got married. So on the wedding day? We don't know each other, so I'm hoping this is okay. During the ceremony, do you remember the ceremony?
Mm-hmm.
Was it before or after you said, I do?
Oh, probably before.
It was before. I was a pastor, remember that. So many times the rings are exchanged before the I do. Why does that matter? It was yours. You brought it into the marriage. It's your separate property. And even in Washington State, there is separate property and community property. Some separate property is things that are gifted to you, certainly things you inherit, award settlements from some lawsuits, and last but not least, things you bring into the marriage. But the minute he says to you, honey, this ring is not big enough for your beauty, let's add another stone to it, you cover that up and say, I've got 9 other fingers, give me another ring. Because the minute he adds a stone to that, he's commingling it, and it's now half his. The terms are trace and commingle. In Washington State, if you do not have proper estate planning, even if everything is community property, it will still depend on how it's titled if everything goes to your spouse or not. There's things that can circumvent that. But community property, you actually have the right to give your separate property and your half of the community property to whoever you want to. It doesn't have to go to your spouse, it's your choice. So taking a look at assets as to what community property and separate property is very important in meeting with an estate planning attorney. And one of the issues is, what is the community property agreement? in Washington, if you want to make sure there is no separate property, and you want to make sure that it does all pass to the spouse with very little work after a death, then a contract called a community property agreement should be signed. Help yourself, help your family, help your friends. We've had a lot of clients whose family moved in from out of state. They had wills in that state, and everything said it goes to the surviving spouse, 100% outright. But no one told them about the community property agreement, so they come in, and one has died, and I gotta break the news to them. I'm sorry, the house was not titled joint tenant right of survivorship. You may need to do a probate to get his interest to you. But I thought we commingled it as community property. Yeah, but he has half the community property, you have half the community property. Prove why you get his. That's what the court is saying to you. It's a very good document, it's a contract, but it is something that if it's the right purpose for you, it's an amazing tool. Much quicker, much easier, much less expensive at a death than going through a probate. But not every couple is that good for. It's got the right tool for the right job. Other things, titling, absolutely. Titling is very important. There's good titling, there's bad titling. We'll start with bad, end on good. Dealing with a client, they had about $900,000. They had $300 in the house, they had $300 in investments, and about $300 in the IRA. The son is dating a girl mom does not like and thinks he's only in it for the money, or she to marry her son. The daughter's a couple years younger, didn't like who she was starting to hang out with. She comes into me and she says, I'd like to put mine in trust until my son and my daughter are at least 30. That's a good start. So, okay, line it all up. I said, now tell me about your assets. Well, this one's in my name. The bank account has them as a beneficiary, and my IRA has the two of them as a beneficiary. Oops. Well, let me kill you off and show you what would happen. Your IRA will be split into two, and they will each get $150,000 when they turn 21. Okay? They can petition at 18, but usually it's 21. Really? She didn't like that idea. And your bank account goes to them automatically, and because your daughter's a minor, it's going to cause a guardianship account. She really didn't like that. She's trying to set everything till 30. So I asked her, please go to your financial planner, let him know about your estate planning, let him know about your concerns for your kids, and then let him know that you want to make your estate plan the beneficiary. Well, here's your deal on the Secure Act. The Secure Act says that within 10 years, if I make my child the beneficiary, they are required to take it out and pay the taxes. She did not want him to have that money over the next 10 years. She wanted it for both of them until they're 30. So if you make your estate or your trust the beneficiary, you only have 5 years. So the Department of Revenue has made a battle between the best income tax protection or the best beneficiary protection. You got to choose. And she said, I would rather pay the income tax and hold on to the principal than them get it too soon. I said, good. Go talk to your financial planner and let me know what's going on. Okay. I get a call from the financial planner. He is mad. He's yelling at me at practicing financial planning, stay in my column, only do estate planning, only do all of this. So I moved it a little bit away, put it on speaker, got some other work done while I was yelling. And then when he was done, I said, I have one question for you. Did you ever ask her about her kids? No. Why would I do that? We didn't have time. I'm busy. I said, great. When you're done asking her about her kids, if she is still your client, you can call me back. Goodbye. She left him, that financial planner. He didn't care about her. And the reality is it would have destroyed completely what they were trying to do. The update on the Secure Act. For those of you who know anything about that, that is the one that says between spouses, yes, you can do a rollover, which means it's as if it was yours, but when you go down a generation, it's now limited to 10 years. If you put it to an estate or a trust, it's limited to 5 years. The Secure Act has been around for several years, and they still have not finalized it. I've just got word 2 weeks ago from our contact in New York that the Secure Act is now at the printers. Okay? And it's supposed to be out sometime this year. If that happens, you will hear about seminars we'll be doing again next year once the dust has settled. And last time they did something like this, which was the Trust Act, we ended up doing about 10 different seminars. Every 2 weeks we did a new one because that many people were interested in knowing what's going on. So be aware of that. For those of you that have dealt with issues of dysfunctional beneficiaries and you have relatively large IRAs, which everybody defines differently, there is going to be a new updated version of a IRA trust, which gives you additional protections, which can take it longer than the 10 years. So, but that'll be coming end of the year, beginning of next year. Keep your ears open, listen to our newsletters, we'll get that to you. But the Secure Act has caused a lot of arguments now about the best income tax protection and the best beneficiary protection. Bottom line, government wants their money. That's why they're doing it.
They want our money.
They want your money, yeah, it's true. They want the tax on the privilege for you to give your money to someone else. That's it, okay. Other sometimes people can do is what's called a quick fix will. They get it online, they get it at a stationery store, and believe it or not, some of them are better than nothing. Some of them. But many times a will is much easier to put in place than a living trust. But if you're just trying to get something there, I've talked to some clients and I've told them, look, you aren't gonna have, anybody's gonna get that done by Thursday. So make sure you go get something, and here's the things you needed to say. And when you get back, if you live, come see me. And I've only had one person cuss me out because he called me, we got everything ready, we rushed it through, he was going to Hawaii. As we got everything done, I told him, it's ready, you leave at the end of the week, come on in and sign. He didn't make it in. So he went to Hawaii. He got caught in the undertow. Ironically, he made it out. And he came to talk to me. He was also a friend of the client. He says, I was so mad at you. And I'm going, I didn't get you caught in the undertow. No, but all I thought going down was, dang it, I didn't go see Ryan. I'm thinking there's something more important to be thinking about right now. It still took him 2.5 years to come in and sign his document.
Oh my gosh. Wow.
I know, he's still alive, but really? Okay, and he knows what I do. Other things that are very, very important on the quick fix is double check your powers of attorney. If you are not one of our clients, you may have a combined one that does both financial and medical together. That is not our style. Many times the people you want to manage your money is that tightwad, analytical CPA, ultra-conservative person. But the ones making the medical decisions, that's your empathetic person. So make sure you choose carefully. The other thing to make sure you have is successors. That's why if you ever see one of our questionnaires, we ask for 3 alternates because life happens. If we didn't learn anything in COVID, we learned people could volunteer to die in the right order. So make sure you have successors in there. Make sure there are alternates so that if something happens to one, you're not left out in the cold with nothing to do. If you have minor children, if you have minor grandchildren, please, if your children or you are going on vacation, tell them to update their financial power of attorney. Why? In the past, for your guardian, you would put the guardianship provisions in your will, which is great if you're dead. Washington finally came up with most of the rest of the country and decided to add something to their financial powers of attorney, where you can put a temporary guardian for your kids inside your power of attorney. So, grandparents, how many of you babysit your grandkids? Yeah, stop that. No more. Not unless your kids have done a power of attorney. We have had situations where the kid hurts themselves, grandkid, you take them to the hospital, as soon as you check them in, you're locked out. And people say that'll never happen. It happened to my family. When my son, at my sister's house, broke his elbow. And my brother-in-law, who's about your height, an ex-football player and coach, decided to take them into the hospital because he called me and said, Ryan, elbows don't bend that way. Oh. So they go in there, check him in, and say, now how are you related to him? Well, I'm the aunt and I'm the uncle. And there's just silence. Well, where are the parents? Well, they're on their way. Will you let us know when they get here, please? And Alex has been taken to the other room. He's now alone at about 6. Not the best method. A power of attorney stops all that. And some of our other seminars, I use an example. Heaven forbid, you should be on a Panama Canal cruise headed eastbound and a pandemic breaks out. Now, that will never happen. But if it did, and you're stuck off the coast of Florida for 3 months during income tax season, and it was your anniversary, so your kids are back home, who has authority to take care of your kids, pay all your bills, make sure everything gets done? That's your powers of attorney. One to make sure all the financial, one to make sure the kids, one to take care of your health. That's in the medical one. So be aware, a quick fix can be a power of attorney. It's a very good tool in those circumstances. Okay? Please,
What did you call that, the power of attorney for a grandparent?
Oh, it's your children doing a durable general power of attorney, just a financial power of attorney.
Okay.
And inside it, they have the ability to put provisions for a temporary guardian for minor children.
Okay, temporary guardian.
Other things to think about, and that is helping others help you. Choosing wisely. And so on page 5, it talks about updating information in your notebook. For those, may I have fun? If you are not one of our clients, make sure you get a notebook. And make one up if you have to. Because one of the things in our notebooks is the last set of tabs. All of that information is designed if you're incapacitated or dead. So you got 6 tabs to put information in to help others help you. Now, I tell my clients this, it is boring as heck to fill this out yourself. Get your kids over there or your beneficiaries, make them be the scribe. You just answer the questions, let them write it down. They've got to read their own handwriting later anyway. But things like, where do you want to be buried? What would you like for your funeral? Where do you keep tax returns? Who do you want them to contact if you died? Writing a letter to your trustee, to your personal representative, to your guardian, to your power of attorney. There's all sorts of things you can put in there to help. Now, there's one section called important information. That's the section where people will put their passwords or how to get a hold of their passwords. Yes, I was joking, but it's real. Most every contract that you sign says if you die, everything involved with that belongs to the company. Most all of them say it. So having someone who knows how to get hold of your passwords or putting in your notebook how to get hold of your passwords is actually very, very important. Now, most people with your notebook, put it on a shelf in the den. Don't sit it next to your computer. Put it with other notebooks. Most times, no one's breaking into your house to steal a notebook. We've had 3 stolen. I've been here 33 years. I've only had 3 stolen. Every time we could figure out which kid took it, when they returned it, and what they made copies of. And every one of them, the parent changed their distributions.
Wow.
And it caused a very interesting fight when one of them showed up after the parent died into our office and said, I'm now in control. I have this amendment. Da, da, da. And I said, really? Yes. And you took that notebook. I told the date, the week he had been there, when he took it, when he put it back, told him what amendment he had and what amendment she was now. And it only took her 1 month to write you out. Next thought, and if you don't leave, we've already called the police.
Wow.
He left really quickly. It was amazing. Don't mess with my trusts. But that's why in the notebook, no one's really breaking in to steal it. So putting in there, if there's a link or someplace, something encrypted, ways to do that. It is really important because passwords is one of the biggest. We even now, talk about updating documents, for now documents that we have a provision in there that covers passwords and covers intellectual properties, because that is still being thought of in the courts in Washington State. And it's still being thought of at the federal level also. It blew to smithereens for people who are doing cryptocurrency and those who lost millions in their investments in cryptocurrency because they forgot their passwords. And it was in the contract. If you don't remember your password, it's ours. And it happened too many times, and boy, those are almost fun to read. But that's why you want to be careful to do that, which, by the way, is the issue of shutting down automatic payments or withdrawals from a bank account. One of the things in getting ready to die is making sure you have in there's a section on your assets. And we encourage people, at least annually, to take out assets that you no longer have, put in a December 31st statement of the current assets you have, and if there's an online password to get into that, put it on that piece of paper. Because they're going to need to do it after you die in order to stop that. The other thing is if you can find copies, then you'll end up putting in there which locations are, because one of the first things we authorize people to do, tell people to do, is every institution that you're aware of, you call them to say, this person has passed away. I know you cannot talk to me. You can't tell me any information, but I would like you to know this is the name, this is the account, this is about what's in there, this is what we're about to do, and we want you to know that account needs to be frozen. Who would you like me to send the death certificate to? Well, when they know you're working with them, they'll work with you. But doing that to stop automatic deposit withdrawals is very important. And it's always said no one can get money out of your account. Well, we know that's not true. But Social Security and pensions are the best. It's gone right away, man. They take that back quickly. Okay, how are you allowed to do that?
Just a couple things I learned. I was my sister's executor, and she passed away 3 years ago. And a couple things I learned that are very important is to have her cell phone and have her cell code. Because so many times websites send for secondary, they'll send you a passcode to log in. And if you don't have the phone, you can't get the passcode. Right. Another thing I learned is that she has a book out on Amazon, a Kindle ADP book.
Intellectual properties.
Well, it's like I couldn't even notify them of her death without doing it from her password or from her email.
Yep.
I tried emailing them from mine just to notify them of her death, and they're like, "We will not communicate with you because we don't recognize your email."
And you're telling them that she's dead, and say, "Well, we need to hear from her."
I know.
That's their standard response. Did you just hear me? She's dead. How do you plan on having that happen?
I know it was quite a learning experience, and I had done my mother's the year before, which was completely different.
Right.
My mother was in Nebraska.
It does say different state. Yeah.
A different state, so they had estate taxes, even though she didn't have a large estate. She had a relatively small estate, but they still have estate taxes, and you have to hire a Nebraska lawyer to do all of that, and it was during COVID, so it was fun.
Very true. And even in the issue of the phones and in the notebook, there are places to make sure you put that information down. The other thing is, for those of you, okay, now I'm going to date myself, the rest of you, grew up with Rolodexes. Okay, I still have the one it's brown, it flips up, and you got the slider on all the out letters. Okay, I kept one just for fun, and so all of those. But no, we then had black books. No, it's all in our phone, which the battery's dead and it's locked. So all your contacts of who you want them to call, what? So one of the sections in there under important information is who would you like contacted if you died? Fill it out. Keep it up to date. Yes.
Oh, question. So even with power of attorney, you couldn't do certain things?
Well, power of attorney doesn't it just
Power of attorney ends when you end.
They die.
Yeah, that's back to fraud again. We have a lot of people who will use a power of attorney to continue to pay bills after someone has died with a bank account. Yeah, completely illegal. It's theft. You can go to jail. No one cares.
Oh.
But it is. And they end when you end. Ironically, there's one exception. Disposal of the remains.
Yeah.
Because we had 3 siblings. Everybody knew what Dad wanted. He was in Friday Harbor. He wanted it cremated. He wanted his ashes dispersed at this island right off from where he could view, go out between the two, dump the ashes. No problem. Everybody knew it. He told them, I was present, clear as a bell. One of the children said, I don't agree. After he died. So because of that, the cemetery still has the body sitting there. 2-3 weeks later, I find out. So I get a call from the one who was in charge and said, I don't know what to do. My sister will not agree. We're at a stalemate. I said, oh, no, you're not. Well, yeah, we are. I said, no. Take your medical power of attorney of your dad's, which you are the agent, to the cemetery. The one exception is disposal of remains. If there's a fight amongst them, that's the time you can still use the power of attorney. She went there, showed it to them, they immediately cleared it, got him cremated. Only took another year for them all to agree dump his remains out there, but that was a different issue. So that's in here, burial and funeral arrangements also. That should be in your notebook, especially if you have prepaid for it. Because yes, it does happen that this family ended up not being able to find the funeral arrangements. They were sure mom had done it. They'd been told mom had done it. No one could find it. They looked everywhere. So they picked the cemetery they thought mom would like to be at. They picked the plot they thought mom would like to be at. They did the casket. They did everything they thought would like to be at. About 3 weeks after the ceremony, so we're a month and a half in, they're cleaning out the hall closet with the coats and the shoes and everything else. In the back, in a shoebox, a completely prepaid cemetery, funeral, plot, everything.
Oh, wow.
Yes, you can resell them. The other option is get a shovel.
Wow. The password thing.
Yes.
Yes. So the thing about getting a master, or just putting them in a, like LastPass, those sort of things.
Yes.
And they have a tool in there, that you can, like a fail-safe or something, so that people can access that vault
Yep.
after you're gone.
Yes.
So I put copies of that in my
In the notebook.
notebook.
Absolutely.
Hope it works.
Yeah.
I'm not that tech savvy, but
Yeah, there's some of those. That's what I say. If you have a system, because there's several of those different companies that will do that for you. And if you do have that system, you need to write it down so people know how to get to it. Real important. Okay, burial and funeral, that's in here. Biographical. The reason biographical information is on there is there is a sheet, a police and notebook, a sheet for 2 of you to fill out all the biographical information. It is line by line what is needed for a death certificate. If you work with funeral homes, you'll find out that death certificates are done wrong. And the family always comes back to the funeral home. This is wrong. Why did you print it this way? I'm really sorry. I apologize. We'll get it right. What can we do? Tell me the right information. Then you go talk to the funeral home. They hand you the sheet of paper given to them by the family. It was wrong. Funeral directors normally, I've not known one yet who blamed the family for that, even though every time that I've dealt with them, it was the family who gave them the wrong information. So make sure you put the right information on that biographical sheet. So all they have to do is hand it to the funeral director. It was 3 days after my dad died. We're sitting in the funeral home and they're asking us questions, and all of us are looking like going, mother's maiden name? I don't even know my grandmother's middle name, and neither did my mom know my dad's mother's maiden name. We finally figured it out, but really? If it had been written down, then you would have had it. And no, that sheet did not exist in our notebooks when my dad died. We put it in since then. Otherwise, I'd be mad at him, but that wasn't true. Okay, things not to do. This is one of those things that is cautious. And we've talked a lot about the things to do. The reason we put these in here, because these are common things people are told they should do. And I even said one yourself, mistakes with do-it-yourself plans. There are a lot of problems and mistakes in doing it yourself. There are a lot of problems, and most of these are involved when you don't get advice. We actually were asked to do a seminar on how to do your own will, how to make your own will. We first thought that was rather ironic that they would ask us to do that. So we investigated the 3 most prominent will makers and ones that were on the internet, ones that have been sold by Costco. We looked through all of them, we made up documents, did all of it to see what it could be, and then we went and had that seminar and we laughed for an hour and a half. The best story was a husband and wife misunderstanding the terms. So, husband puts this will together and gave all of the personal effects to his wife. And then if she's dead, it goes to the kids. But then put the provision that if you're all dead, then everything can go to my brother and his kids. Personal effects is the furniture, furnishing, clothing, jewelry, collections, everything not nailed down in the house. It wasn't the house. It wasn't the bank account. It wasn't the securities. That he gave all to his brother. They were in our office asking how the heck to appropriate the will because he just died. Make sure if you are going to get a do-it-yourself document, you get advice on what to put in there and what not to put in there. That's why I said in a dire emergency. Yeah, there's times when I will even recommend it. But realistically, if you really want to do creative and thorough on an estate plan, doing it yourself can have some problems. There are also mistakes in signing formalities. We just have Sabrina's? Is that Sabrina's the one-page will? Someone just brought in a one-page will. It says, I leave all my stuff, and listed 5 beneficiaries, and the witnesses were 2 of the beneficiaries. Oops. So was it a valid will? Yes. They witnessed it. But now, because it was only witnessed, they got to go get an affidavit, so hopefully they're still alive. And second, then, okay, but you are going to make this a valid will, then you don't get your inheritance. So which do you want to be? And without the will, it would have gone to different people. Ooh. And guess what? One of those who would have gotten more without a will is the one contesting now. Surprise! So be careful. Mistakes with titling, absolutely. That's the example I used earlier of the client with a son and a daughter. They're too young. You want to make sure that when you do your estate planning, you may have the absolute most wonderful estate plan in the world, but if there are beneficiary designations that send that asset over there, it's not going to accomplish your goals. So making sure you tie in what you do in your documents with what you do on institutional documents is very, very important. They need to go together. Mistakes with gifting. This one has not been as prominent recently, but it has been a lot in the past. And that is mom and dad about to die, so they gift their house to the one of their children that they'd like to get that house when they die. Problem is, the surviving parent had been in that house for about 30 years from before the first parent died. The cost basis was nearly $1 million. She gifted it right before she died, which means the son got a cost basis of the lower amount. It will cost about an extra $80,000 in capital gains. 20%. No, yeah, 20% of that, $200,000, not $80,000, $200,000 of capital gains, because she gifted to him. She gifted the cost basis. So you got to be careful when you do gifting as to what type of assets you are doing the gifting on, and you should always talk to the CPA and a financial planner before you make large gifts like that, because it could be very damaging, won't hurt you, and yes, they'll get the asset, but they may not be getting everything you'd like them to be getting. So there's other ways to do it.
In a case like that, instead of gifting a house to your kids or whatever, or can you do like a transfer on death deed?
In Washington, you can. A transfer on death deed, its primary purpose when you do estate planning is if you are setting up a revocable living trust and you have a second piece of property, not your primary residence, there is a due on transfer clause in the mortgage, if there's one. And if you were to gift it into your transfer it into your living trust, the mortgage company can call it the mortgage due because it's not your primary residence. So a transfer on death deed is used until you've paid off the mortgage. That way, the property at your death, if you died before it's done, will go into the trust to avoid there being a due on sale clause. There is a due on death clause. That is why it's the best, because it's going into your own living trust. What people have found out is if you do a transfer on death deed to a child, you have effectively given an interest to that child. So first, if you ever want to revoke that, they have to sign off. Second, you ever want to refinance, they have to sign off. You ever want to sell it, part of it is theirs. So there are some dangers for transfer on death deeds. It is very effective when there's only one beneficiary though, and or the trust. So there's some good times for it. The other thing is the state that was the most prominent in doing all of this was California. They have run into so many lawsuits that the estate planning attorneys that I work with in Southern California will not even do them anymore. This is just, it's too big a pain. We go ahead and we do the quitclaim deed right into the trust, we just don't record it. It's a pocket deed. If they die, then we'll record it. Or we'll wait till they pay the mortgage off, because there have been so many lawsuits on the transfer and death deed. So I thought that was a rather interesting way to do it. How to use an unexpected reprieve. Normally, when a person dies without any estate planning, or a person dies with just a will, that normally would go through a probate. There are times when people want to avoid that. One of the ways people do that is through beneficiary designations. Another way they do that is community property agreement. Another way they do that is a revocable living trust. So just be aware that that is one tool that some people use. You'll see later on that there are pluses and minuses to wills and trusts, but people ask, well, how do I avoid a probate? Well, that's one way. The thing about probate in Washington State is some attorneys swear by probates and some attorneys swear at probates. How does that work out? Well, those that swear by probates will always sell you a will. Because when you die, I don't care what I quoted you the price on the probate, well, prices have increased since then when I'm meeting with your kids. And so they always do that. And by the way, if they're doing you a will, they will always hold on to the original for your protection and for your benefit. Yeah, no. Those that swear at probates, they'll always try to sell a living trust. Why? Because then it can avoid probate, and I don't have to know your kids or your beneficiaries. I've already been paid the big price up front. So you want to be careful of that if you're looking around in estate planning attorneys. The reality is it's not our choice. The attorney should educate you on what they both do. And one of the tools to avoid a probate, if it fits your needs, is a living trust. But it has to be one that fits your needs. And you'll see there's other things that factor into that. Estate tax planning. I was with the client this week, husband and wife, they're about $3 million, and we're talking about that, and I get to the hunk and the bimbo clause. For those who've met with me, you know that one. It's the second marriage issue. And you always pick on the guy, but you don't let him know you're picking on him, you pick on the girl first. So you say, I just have a question. If I kill him off, who are you going to marry?
I have no idea.
Yeah, it's I have no idea or not again. Yeah, I already trained one of you once, I'm not trained again. But then you turn and say, okay, but if I kill you off, who's he gonna marry?
I have no idea.
And the conversation changes. Yeah. And sometimes the guy, puffs up, I wouldn't marry either. Yeah, right. Okay. Statistically, more widows stay single than widowers. And statistically, guys don't like to be left alone and get distracted by most things in a skirt. Okay. So then you just ask the next question. How would you feel if you died first, gave everything to him, then he married the bimbo and wants to give it to her and her kids? Are you good with that rather than your beneficiaries?
No.
Some are, some are not. That's one of the protections of a predator. Well, if you are doing that protection, you also have estate tax protection. Because the next thing I said to them was, by the way, at $3 million, if you give everything to him and then I kill him off, I hired Guido, he's really, really good. I kill him off, he's over by $800,000. So for your beneficiaries, that's about 10 to 15%, so about $80,000 is gonna go to Washington State, #1 charity, instead of your beneficiaries. How's that work out for you guys? They immediately changed what they were thinking. That estate tax planning became important. Because even though we both have in the state 2.193, everyone just says 2.2 million, as an exemption, if I give everything outright to my wife, Sandy, then I threw away my exemption. When she dies, she's only got one. There's no portability like at the federal one. So if estate tax planning is one of your goals, doing a simple I love you will is not going to cover that. So be cautious of that. Last but not least is asset protection, and that's from a second marriage, or asset protection because the person who died is in a business that's easily sued. When my dad died, he was still practicing. We were here till 5 o'clock that night. And that night he passed away. Did we do protections for my mom because of that? Absolutely. He was still practicing law. So we wanted asset protections over his money, so if something happened to mom, they couldn't get after his money. It would take care of her. If those are your concerns, then you need to be a bit more thorough on what estate planning you do in getting ready to die. It comes back to goals. And of all the different tools, they accomplish different things, so make sure that the tool you use accomplishes the goals you want. Okay? Checklist. That's just a fun checklist. We just put that in there so you can see it. There are things as you do your planning you should consider if you really do want to be thorough. And so some of the next things on page 9 are the tools. And we have talked about some of these, and we're going to talk a bit more in depth on them again. But be aware, these are all parts of what can be tools in doing proper estate planning. It's up to you which ones meet your goals. Yes, we think everybody should have the incapacity documents, financial power of attorney, healthcare directive, and the HIPAA release. But whether you choose a will or a trust should be based on your goals. A community property agreement, estate tax protection. We have plenty of clients that are over the estate tax limit, but are going to give everything above the limit to charities. That way they don't have to worry about anything else at the first step. Everything just stays with the spouse, no extra tax returns, no divisions, no nothing. It's all theirs. Spend it, give it away, keep going to charities. We've avoided the estate taxes, and your other beneficiaries can have the rest. Okay? It's your choice. It's your money. An inheritance is a privilege, not a right. No one should have demands on their inheritance from you. It's your money. Do with it what you'd like to do with it. Okay? So, page 10, we talk about different ways titling can take place. And we briefly talked about this. One is joint bank accounts and understanding how banks view this. If two of you are on a bank account, just together on it, there is a primary social security number. That is the one that the credit ratings will be going to, just like a credit card. But banks treat accounts as joint tenant with right of survivorship unless you clearly state on the account it's tenants in common, which means you both own 100%. And if one of you dies, it all goes to the other. And many times with bank accounts, that's great, unless there's separate sets of kids and separate sets of beneficiaries. The other issue about joint bank accounts, and for that very same reason, you do not add your child onto your bank account as a co-owner. Why? It's theirs. They can go in there and clean you out. And if you die and you have multiple kids, the one who's on the account gets it all. If they're all on the account, then watch the race. The first one there gets it all. The other dynamic is you only put one of them on there and you die, even if they want to share with their siblings. That's a gift. And there may be gift tax consequences. Last but not least, if your child on your account gets in a car accident, a divorce, a bad business deal, and gets sued, they will come after your money. The worst case I heard was one of my clients who had about $100,000 in there. Son got divorced. Wife had a great attorney, ex-wife. She went after the account and said he'd been squirreling money away from work for the last X number of years, and she was entitled to half of the $100,000. It took her $10,000 to hire a forensic accounting to cover all of the years to prove it was just her money. And she couldn't get attorney fees back. Don't do that. Danger. Okay, there's other ways, like a power of attorney.
Perhaps a myth, but I was told that in preparing for our death and making funds available for our children to take care of us, that we would put them on the checking account. So what other tool would you recommend we use so they have ready cash, if you will? Let's say 10 grand, 20, whatever it will be.
At the time of the death?
For the first month or so.
Yeah, we have a lot of clients who will do that. The issue is, if you die and no one is on that account, then who can pay your bills? Well, the reality is most places will accept a credit card. And so most times during that month where things are being settled, or 6 weeks, someone of the kids puts it on their account, puts it on their credit card, and they get reimbursed. But yes, we have a lot of clients who will take a second account, a savings, a money market. They will keep it separate from all the other ones. And on that one, they'll put whoever their beneficiaries are, all of them. And they will make it clear to them, this is what this account is for. Understanding that they don't have to follow your wishes. You're dead. But doing it in a way that, yes, they would have ready access for this money to pay the funeral, to pay things that might need to be paid, other final bills, etc. If you're going to do that, and I don't sell cemetery plots, I strongly recommend you prepay for your service. Because right now, that will go, even in the least expensive, between $10,000 and $30,000. So make sure that you've prepaid everything you can prepay So then when you have the 10,000, that'll be for all the peripheral stuff. Okay? And people choose what amount they want. Do keep it under $100,000 of all accounts that are out there in your names. Because there is a small state affidavit in Washington State you can use if they disregard the co-owners. If they try to lock it up, there's an affidavit you can do instead of a probate at that time. So just be aware of that. Okay. Another thing, a myth, is I will put my kids on all my accounts and beneficiary designations and all the rest, so the minute after my death, all of my assets will transfer to them, and therefore I have no assets and there will be no estate taxes. I had someone try to do that to the tune of about $3 million. I had to break the news to him. Department of Revenue has heard that one before, and in their wisdom and infinite knowledge, they charge you on everything you own 1 second before you die. And the beneficiary changes occur 1 second after you die. That's not a way to avoid estate taxes by making beneficiaries. And it can be dangerous if they go and spend the money right away and then get a notice from the lawyer that they're responsible for a proportionate amount of the taxes due. It's quite an eye-opener. So again, doing proper planning, proper preparation would be very important in those circumstances. IRAs and 401ks, again, the Secure Act, again, I'll briefly say, hopefully, before the end of the year, there'll be more clarity. But at least at this point in time, the issue is between spouses, if you want to give everything to your spouse, you can make them a beneficiary and they can do a rollover IRA. If it's a 401k, they convert it to an IRA, then they can do the same. If you put a secondary beneficiary to people, they will receive it. If they are minors, between 21 and 31, they have to cash it out. If they're over that, then they start at the time of your death. Over the next 10 years, they cash it out. There are exceptions if the beneficiary is autistic or Downs. And the danger is, what happens if it's a second marriage and you have separate sets of kids? And you want to take care of your spouse, but after your spouse dies, you want it to go on down to your kids, and hers could go back to her kids. Well, you're in a quandary. If you make her the beneficiary, it is hers. You make him the beneficiary, he can do whatever he wants to with it. So be careful what you do with that. But again, that's why they're looking into the IRA trust. The other is if you have dysfunctional kids. And if you have dysfunctional kids and you do not want them to have that over the next 10 years, you got to go for Plan B, which right now means the tax will be paid over 5 years, not 10 years. Once the final regs are out, we'll learn more about how that goes. But that one, the Department of Revenue is made really ugly now. So just be aware of that.
Quick question
Please.
regarding that last slide, back to the credit card
Oh, yes.
business. I was the executor for my mother. I wanted to do my job and pay off her credit card. I had an idea how much it was, but nobody was asking for it in the bill yet, so I said, I'd like to pay it off. Well, don't worry about it, it's not your problem. So it's my problem because I am the estate, okay? And they said, well, you can take your money if you want. I said, okay, well, how much does she owe? Oh, we can't tell you that.
But they'll take the money.
Well, we played 20 questions, is it below this or above this, and finally, I went ahead and paid close to what it was, but then I was told later, oh, you shouldn't have paid him anything because they almost always forgive the debt on the credit card. So is that true or a myth?
Yes. First thing to understand is that all debts after a death are negotiable. And so one of the questions is, for medical bills, credit cards, the question is it a valid debt? And yes, there's a process where you have a will or living trust called creditor's claims, either probate creditor's claims or non-probate creditor's claims. And in that process, it's a legal chess match where if someone thinks the deceased owes them money, they are to file with the court, with the person in charge, and with the attorney who published this, that this is a valid debt. And then they are to prove it. The other benefit for that is when it's proven and paid, they will then send you a document that has proof to you that it's paid. Because what happens is, if during this time, the left hand and the right hand don't know what they're doing, they will turn it over to a creditor, to a claims company to come after you. And even if you paid it off, they don't know that and they have no proof of that. And now you're getting all this horrible things. So do some creditors write them off? Yes. Are there some of them that have insurance on them to pay them off? Yes. Can they tell you that? No. Not until you're appointed. Once you're appointed in a will as personal representative, as a trust, as a trustee, then you have the authority to negotiate with them. But yes, all debts are negotiable. You're already at no. This is what they owe. Can you make it less? No. Okay, that's where I was to start with. If they say yes, you're ahead of the game. Yep. Yeah. Settling estates. Always fun. Yes, please.
When I was an executor on the state, 30, 40 years ago, and one of the things that I was told that I couldn't pay any of the creditors, because if I paid one, any amount, and did not have enough money to pay all of them at the end, that I was liable.
Yep, that's still true.
Yeah, so you gotta be very careful about what you pay, because it can come back on you.
Mm-hmm.
And
What he's talking about is an insolvent estate. You have this much assets, you have this much creditors. The state has an order that creditors are to be paid. Guess who's number one? The government, absolutely. Guess who's number two? Come on, who wrote the rules? No, who wrote the rules about settling the state?
Attorney.
Yes, they're number two. They put themselves number two, a little bit below the government. And then after that, they go down to secured debts and unsecured debts. And if you run out of money at any one of these categories, it has to be proportionate based on how many creditors are in that category. And if you only pay this one, all of these guys can come back and sue personally the personal representative for sending their money to someone else. It's still in effect. Yeah. So anytime someone has more debts than assets, the best thing to do, flee.
yeah,
Just
I was
run.
lucky the estate did end up having enough money to pay everybody.
Good. Yeah, those are
Well,
difficult.
The other thing that happened is that halfway, 6 months into the probate, I get a letter from a lawyer. The deceased person was being sued for a traffic accident. So they wanted $30,000. So if you've already spent money out of the account and you have to pay that claim, I mean, there was no way of knowing that she was getting sued.
Right. Yeah,
You
that's the
never
difficult
really
part.
know that's why you have to wait a year, because.
Well, that's where creditors' claims come in, because it's an unknown creditor. And creditors' claims, statute of limitations is between 2 and 7 years, depending on who it is. Creditors' claims shortens that down to 4 months. If they had done a timely creditors' claims, and that 4 months had expired, and they had not notified you, and there was no way you could have known that, then they could have been written out.
Right.
Yeah, that's one of the fun ones. That's why even when people do a living trust, there are times you will do a creditor's claims at the death. We did that for my dad, because that way you may not know who's out there. So establishing a creditor's claims and shortening that time frame is huge. So you're not looking over your shoulder.
Is that the notice that goes into the paper or?
Yes, Daily Journal of Commerce. It's not your obituary. It's a specific publication.
Right.
It's published 3 consecutive weeks. The 4-month period starts from the first publication. So that's what that is.
Yeah, this process sounds like bankruptcy.
Close, different timeframes, which is why I don't deal with bankruptcy. Yep. Other things about powers of attorney, you will hear the power of attorney is too old, it has grown stale. That is not a legal term. That is an institutional term. And for a while there, institutions, and both financial and medical, were saying, if a power of attorney is over 4 years old, we will not honor it. Because they've been sued too many times by someone bringing an old power of attorney, they do all these things, and then no one shows up. So they didn't want to get into that anymore. So the state of Washington was not too pleased with them. So the Bar Association put in a provision. If you are running into a problem with a power of attorney because it's so old that they don't want to honor it, if you go back to the law firm that did the power of attorney and they do an attorney's certification on it and have that filed with the court, that is bringing it to the current date to supersede anything else. So they put in another way to get around that. So just be aware. The predicament is, the other thing they'll tell you is just have them sign another one. You realize I'm here because they're incapacitated, right?
Yeah.
Oh yeah, you mentioned that. So how am I supposed to have them sign another one? I'll just hold their hand and then, but that's their standard thing. Just have them do another one. That may not be possible. So that's where the attorney certification comes in.
How old is old?
Every institution does it differently. We had one point in time, in about a month and a half, we had 3 different financial institutions. One sent the letter 5 years, one sent it for 3 years, and one sent it for 4 years. We got them all in. Really? You couldn't all agree. So it really is that. What we recommend when new clients come in to see us, and even some of mine that come back for their reviews, if their powers of attorney are not, they don't want to change who's in control, I tell them, go to your bank, show them this power of attorney, and ask them, will they still honor it based on the date? Take your medical power of attorney to your doctor. After the doctor picks their job, because you actually have one, ask them, will they honor it? Well, with all the bank mergers, that's changing. So make sure if you've given your power of attorney for healthcare to your bank, you double check that they still have it on your records. Because with a lot of mergers, those have disappeared all of a sudden. And so you want to go back and ask, will you still honor this based on the data? Okay? The other thing, and this is just a picky thing for me, hospitals always ask, do you have a directive to physician? My answer is always yes. Can I have a copy? No. And it just stops them dead in their tracks. They don't know what to do with that. Here's my medical power of attorney. This is the person that controls my financial power of attorney. This is, or the please unplug me document. You want the please unplug me? If it comes to them, ask them. They know my instructions. Because I don't want a hospital to put pressure on my family because they know I've signed that document. Oh, that'll never happen. Oh, yes, it will. These people became clients of mine after the fact. After Dad died, they needed to settle the estate. I always ask, tell me about how your father's passing was, how your husband's passing was. I'll kill you off. These are my clients. Kill you off. So we were having that discussion. Come to find out, you were in a coma for about a week. And now's the time to unplug you, brain dead, no recovery, and they have it in the room asking you, it's now time to do this. He's been here long enough. 2 of the 3 kids were there. What the hospital did not know is the family had been in agreement that they would never unplug one of the 2 parents unless all 3 kids have been there and had a chance to say goodbye. Guess who was on the road to the hospital when the hospital put that pressure on them? So they stood their ground, but they had to stand their ground and fight with the hospital? I always give the medical power of attorney. I'm not going to give my directive. They don't need it. They just want it. Okay. If you don't want to do this on me, the surgery, whatever it is, great. I know other hospitals that will. They freak out at that comment too. It's sort of interesting. So those are some things about that. The issue of guardianship, if you become incapacitated, a power of attorney can stave off a guardianship for a period of time if all you have is a will. The predicament is, again, some institutions may claim that it is stale, too old, or claim that they're just not going to honor it anymore. And that's why if you have a will, even with good powers of attorney, there have been some clients who were still forced to do a guardianship. So one of the things to review is if you have a debilitating disease diagnosis, Parkinson's, Alzheimer's, dementia, any other of those that might be debilitating to you, that's time to review your estate plan. When you asked about when is appropriate to review, what we say, and you'll see it in our newsletters, a life event or every 4 years. What's a life event? Someone that's born that should be included or excluded. If you have a grandchild that's autistic or Downs, go get your documents reviewed. You have an in-law, marriage or divorce, that is really an outlaw, get your documents reviewed. Too many stories on that one. A debilitating disease of you, get them reviewed. Someone dies, whether it be a beneficiary, a family member, a parent, one of your powers of attorney or trustees. Those are all times to review your documents. If you have one of ours, you'll probably notice that there's already a backup in there. That's why we ask those annoying questions. I've killed that person off. Who do you want next? Why'd you kill them off? Because they were in the way. Oh, okay. So make sure you look at your documents, any of those defining life events. And certainly, if nothing else comes up every 4 years, get it out, look at it and go, what was I thinking? Life happens to you and life happens to others. And sometimes it's appropriate to do that. Do not be like the family who came to when mom and dad had died. The kids are in their 30s. They sat down on the will and their first question to me was, do you know who we have to go live with now? Because mom and dad did their will when their kids were guardians. I always make a suggestion. Get an empty suitcase, go to them in person with the suitcase at the front door to tell them your mom and dad have died, they're now your guardians, and ask them which room is yours. I only have one client who did that. It was hilarious. Things to think about. Healthcare power of attorney, I've already mentioned this one a bit. The main things to remember about a healthcare power of attorney is your life is in their hands. These are also the ones that are in control if you have authorized organ donation. And these are also the ones in control if you have authorized that you want to be unplugged. So choosing carefully. The other thing which is the most common in a medical power of attorney over financial or a will or a trust is making people together. So you would put two people as or, which means first one there, make the decision. Don't let me bleed out because you can't find your brother. Or and, because you want them both to have a say. Can you do this in your financial? Yes. Can you do it in your medical? Yes. Can you do it in a will and in a trust? Yes, you can. Remember the 4 categories for all of these jobs is immediate kids, other family members, best friends who you wish were family members, or professionals. And we recommend you start this way and work that way. But if you want some neutral, or if they don't get along and you don't put one over the other, skip the first one, keep going. The reason we put ourselves last is because we're the most expensive. Yes, we have the most to lose if we screw it up. Yes, we're running 170 plus trusts right now. Why? They wanted neutral. They wanted someone else that could be involved and be around because other people died. But we were last resort. So that's what you want to think about is those categories for your powers of attorney, financial, healthcare, as well as for who would be the one in charge after you die.
I have a 22-year-old grandson. If I was advising him, what is the minimum kind of documents he should have?
What would be the minimum documents anybody should have over the age of 18?
Yes.
I'm gonna tell stories on Alex again. She knows Alex, actually they all know my son. Never mind, they'll love it. We recommend anybody reaching the age of 18, minimum documents is a financial power of attorney, a healthcare power of attorney, and a direct-elected physician. If they go away to college or they're just out traveling around and they get in a car accident, if they are over the age of 18, you can do nothing for them unless you get a court order or a guardianship over them. I think it's $650 for all 3 documents and the HIPAA release. I think that's right per person. And it gets all of those in there because immediately that allows someone to be able to stand in their shoes for paying bills or for making medical decisions or if they need to be unplugged and if they're in favor of organ donation. So that's the minimum. We recommend it for anybody over the age of 18. The joke, in case some of you may know my sons, our oldest is our problem child. He knows that. We know that. We told him, he's in the middle of his senior year. It is January. You have 2 weeks from your birthday to come in and sign these documents or move out of the house. Now, I know all the stories and when this goes bad, so he knows too. And he knows if I'm going to say that, I'm not joking. It still took him 2 weeks to sign. Seriously, Alex? But it did. But he signed them, but you got to do it. Because otherwise, there's so much more expensive ways to settle things if something like that happens. Okay? Okay. Directed to physician, I'll simplify that. Please unplug me. Community property agreement, we've talked about that. We've talked, I believe, about community property enough. Did I fully answer the question about community property for you? I think it was your question.
Yeah,
Okay, good.
well, let me ask this.
Okay.
If you don't have a community property agreement and one of the spouses died, does anything go into probate because of that, or how do you get the house to go over to the spouse that survives?
Okay. If you only have a will, the house is in your name, even though we're a community property state, I need you to look on the deed. If the deed has your two names as husband and wife, the title company treats that as tenants in common, which means you both own half of the interest in the home. And so yes, at a death, you have to do something else to prove that it is you are the one who gets the decedent's interest. Normally, in most situations, that is doing a probate. If, in fact, all of the liquidity and the house have all transferred over to you, but you find just a couple of bank accounts, and the total value is under $100,000, normally, attorneys will tell you that is also probate. Both of those are wrong. Washington and most states have what's called a small estate affidavit, which only applies to liquidity under $100,000, no real property, all debts accounted for. You can do an affidavit. It's $2,000 to $3,000 when it's all said and done versus $8,000 to $12,000 in a probate. If it is real property and all other assets transferred to the spouse, they have what's called a lack of probate affidavit. It was put together by the title companies. Over the decades, the last 3 that I've used it, it has been all over the world as to who you could use it for until too many people misused it. Now they are limiting it to just husbands and wives. And the only exception we've gotten is if it's the second one to die and there's only one beneficiary. And there was a will showing that that was the person who got it all. They'll make an exception. Because again, an affidavit is about a quarter of the cost of doing a full-blown probate and a whole lot less time. So other than doing a full-blown probate, if it is real property and everything else passed, you can do what's called a lack of probate affidavit. But that's only real property, and I've had some states who do not want to do it, but Washington will still do it. Okay?
Thank you.
Page 15, we talk about the will, what it needs to say. That's a little bit more in depth there of the requirements of a will. We also talked about who do you choose, and that's where I went down. You've got your immediate family, extended family, best friends, and you got professionals. A revocable living trust, there's a little bit more information there about living trusts and what the trust must say. This is the overall document. This is not distribution provisions. That's a testamentary, irrevocable trust. This is your main tool instead of using a will. If you have a revocable living trust, you still have a will. Its nickname is a pour-over will. It's a last will and testament that says, I have a trust. Oops, I left an asset out. It comes through probate, scoops up that asset, and pours it over into your trust. So it's a professional pooper scooper. So that's what it's trying to do. But a pour-over will also revokes any other wills you have. It pours things into your trust. It is used when you have a living trust and you want to do creditor's claims. You have to file it. And last but not least, if there's a wrongful death lawsuit, accident, asbestos, all the ones that were really huge 10 years ago, all of those types of lawsuits, they still want to have a personal representative. That's why they sent the letter to you as personal representative, because there's someone that can serve. So be aware that you do still have a will, but rather than it being 20 to 30 pages long, it's usually 4. Because all it's doing is getting things over to the trust, getting rid of the ones, being available if you need it. Okay. The one sheet that clients have liked a lot is 17. The reason I bring up this one is because it's really helped a lot of people when they're trying to decide what tool they want to use. This is a side-by-side pluses and minuses to both tools. And if it's someone who's new in estate planning with us, what I ask them to do is go through and cross off everything that does not matter. Because gradually then you'll determine what your goals are. And as you determine what your goals are, that's what helps you determine what tool to get. So it's a really good one for doing that and to use that. Okay. There were a couple of questions that we did not cover. Oh, there's only one. Hold on, I'll cover other questions in just a minute. The one we didn't, no, two, sorry. Charities and the Secure Act. In the past, we do not know how the Secure Act is going to change this. So far, they said they haven't touched it. Really? In the past, if you had an IRA and you made a person the beneficiary, spouse or child or other person, they had the life expectancy of that beneficiary to be able to take payments out of that IRA. Even your kids could do that. The Secure Act that said spouses can do it, but kids have to do it in 10 years. The predicament is a charity does not have a life expectancy. So what would occur is you would make this charity for 50% and this son for 50%, and then when they do the audit of that, they say, well, great, because this one does not have a life expectancy, we will not honor his either. And with a charity, they pay out the full IRA right at that time, but because they're a charity, they don't have to pay the income tax. But the beneficiary also has to pay it out all at that time and doesn't avoid the income tax. So you do $1 million property, IRA, and you do $500,000 to the charity and $500,000 to your son, you gave him $500,000 of ordinary income. You account for it the first year, you pay the tax over the next 5. Which is why we think the Secure Act said if you make the charity, if you make your trust the beneficiary or your will the beneficiary of your IRA, then your beneficiary only has 5 years to pay the tax. They were following their own pattern. We don't yet know if they're going to stay with that or change that. They've not said they're changing it. So that's why we have clients who, rather than putting in their estate planning what their charities are, because many times they want to change their charities all the time. You got 2 choices. Keep paying me lots of money. Or carve out, I'll pick a number out of the air, $100,000. This is how much you'd like to go to charities. And break your IRA into 2. This will be people, this will be charities. It completely eliminates the IRS from being able to muddy the waters. And that way, every time you want to change what your charities are, just do a new beneficiary form. Don't come pay me to update your document. So that's why charities and people are recommended to not be beneficiaries of the same IRA. If it's a small amount, and everybody defines small in the same way, in different ways. So if that amount isn't going to cause that big of an income tax hit to whoever your person beneficiary is, then it doesn't matter. But for many people, there's a different penalty that will occur. So that's why people have tried to separate those 2 out. Does that help? Okay. The other one, date of death.
Wait a minute. Does it make a difference if your child is over 55?
It makes a difference what age you are, not the child.
Okay.
It makes a difference if the beneficiary is another person other than your child and there's a less than 15-year difference. There's all sorts of ones that were before that so far the Secure Act says, oh, we'll just stick with those. But those contradict what you've said. So we're really waiting for the rigs to come back out and go, okay, you said you're still applying, but these 2 fight each other. Which one applies? That's what they're supposed to be finalizing. Don't hold your breath. People have been holding it for 4 years. It's really ugly.
How many pages is
print? I don't know. My friend in New York, his idea of a fun day is to go argue with the IRS. Man, I'm glad there are people like you, so I don't have to be that.
Okay, I'm not entirely clear on this, so let me ask this.
Absolutely.
Okay, if in a specific IRA,
Yep.
you have X number of dollars to a specific charity, same IRA, X number of dollars or percentages to, we'll say, 3 other people. And these three individuals theirs would be going like, so we can get it over 10 years.
No.
Okay, so.
Nope.
You can't mix them.
The way the IRS has interpreted that is because a charity does not have a life expectancy, the whole IRA has to be distributed outright, right now, to all the beneficiaries. And if that results in greater income tax, you pay greater income tax. That's what their rules are. We're waiting to see if they're gonna change it. They've not said they are, but they haven't said they are.
Is there a differentiation between a regular and a Roth with respect to what we've been talking about?
Is there a difference between regulation, a traditional IRA and a Roth IRA? Yes. Do you want me to answer the rest of the question too? Okay, fine.
What is it?
Roths are great to be using because they've already had income tax paid on them. So no one really cares. Roths are great if you have kids that are dysfunctional or other beneficiaries that are dysfunctional and you want it held for a longer period of time. Because when it comes out into your estate plan, there's no income tax due. So you can put it for whatever terms you want. So normally, if you're going to use a charity inside your estate plan, you put the terms, not on the IRA. When it comes to charities, most people, if they're going to do that, use traditional IRAs, not Roth IRAs, because they've already had the income tax paid on them.
But I guess with regard to the payout, well, Roths, is there a?
I think
limit
Roths are
on
5 years
how it
ago.
has to be withdrawn?
Yeah, I think it's 5 years,
Same as,
period. Last I heard, Roths are 5-year period payout.
but they're not even 10 years.
I don't believe so, because they've already had income tax paid once, so they don't really care about that. What they care about is they don't want that Roth to sit there 10 years before the new income has to be taxed. Because from the date of death forward, all income earned on that is taxable. So you put in 50,000 into a Roth IRA, date of death it's 100, in 5 years it's 125, that 25 has still got tax due on it, not the 100. So they want that reintroduced into the community, so someone has to pay income tax on what it's earned, sooner rather than later. A lot of fun. Yes, please.
When it comes to a 401k, for example, is that happening outside of probate if things wind up in probate, or does that count toward the taxable estate for estate tax purposes, or does that happen outside like a life insurance policy?
Ooh, boy, 4 questions. Okay, good. No, yes, and no. You gotta remember the questions in order. No, it is not outside of what happens, but it does not go through probate if you have a beneficiary designation on it. Does a 401k avoid estate taxes? Absolutely not. Even if you have a beneficiary. That was 3. 4, you brought in life insurance. Life insurance has a myth to it. The myth is someone is a true salesman only of life insurance. You will hear the phrase, life insurance is not taxable. That's not true. That's a half statement. Life insurance proceeds are not income taxable. Life insurance proceeds potentially are estate taxable. So when you mention life insurance and not paying estate taxes, that depends on who the owner and the beneficiary, the owner of the life insurance policy is. Not even the beneficiary, is the owner. Because they will drag that in. Remember my comment that the IRS will tax you on everything you own 1 second before you die? They make their own exception. They will tax you on the full face value of insurance you own on your death, if it's on you, 1 second before you die, even though it doesn't pay out to 1 second after you die. Thank you for playing. So again, looking at life insurance and what your goals are, if it's going to be for estate tax protection, you just get out of your estate into an irrevocable trust. But when it comes to a 401k, if it's a surviving spouse, they normally have to roll it into an IRA, and then you're following those rules also. Now, there was the last question that was asked that I haven't answered, and I know we're overdue by 5. If anybody needs to leave, please feel free. I will not be offended. I'll just break down in tears after you leave. Okay, you talked about date of death and getting a deed. On the deed, doing a date of death valuation. The reason you get a licensed appraiser, I don't use a market analysis, I don't use Zillow, I don't use the property taxes. If someone has died and owns real property in every state, including mineral rights and deeded timeshares, I will get a licensed appraisal to tell me the value of it. Because if I buy it for $100,000, I die, that cost basis of $100,000 moves to the date of death value. And if it's $1 million and I had sold it right before I died, I have 20% tax on $900,000, $180,000. If I wait till I die, my cost basis steps up to the current market value. In Washington being a community property state, for Sandy and myself, if it is a community property house, both sides step up. But if I die and Sandy had inherited a house and it is her separate property, that doesn't step up, she's not dead. If I inherit a house and it's my separate property, it will step up in my death. So getting a licensed appraisal, the reason you do it that way is because you're gonna go into a gunfight with the IRS. Because eventually when you sell it, you're gonna tell them your value is $1 million. And they're gonna say, prove it. And if you have Zillow or property taxes or someone could sell it for this, it's like going with a BB gun into a gunfight with the IRS. If you go with a licensed appraisal, that's like a bazooka. I'm taking the bazooka. And so licensed appraisal is very, very important. Your other question was, are there other things? Absolutely. All real property, not in IRAs, but all other securities, bank accounts, you do want to establish a date of death value as well. And financial planners can do that for you if you're using one. The reason, again, is cost basis. You want to eliminate old cost basis to the current new cost basis. And there's all sorts of other little nuances depending on whether the market's going up or going down or all these other things. 6-month alternate valuation date and all these. That is why I am not a CPA, just so you know. But that whole dynamic of getting a date of death, clear date of death value on all assets helps to determine whether or not you're going to do an estate tax return. And again, some people say, well, the estate's only $2 million, we're not over the 2.2, we're not going to do the estate tax return. Talk to your CPA first. With an estate tax return, you are putting down the licensed appraisal on all real estate. You're submitting that to the Department of Revenue, the IRS, and they will send you a clearance letter that they have accepted your tax return. There's no tax due. What they accepted was your valuations. So at a future date, we've had clients go back and say, okay, I'm selling it now. Here's my cost basis. Here's what I have to pay in capital gains. And I goes, wait a minute. How come you only have to pay that much? I thought the cost basis was something else. You remember that tax return I filed when my husband died? That was the cost basis. And you already said yes. Don't argue. So having that date of death valuation on securities, on real estate, other things with a cost basis is very, very important. We even have some clients who will do that with jewelry that's over $1,000. Certainly if you have gold bars, if you have silver bars, you do it on those as well. Get a date of value, get proof of it. Because if it continues to go up when you sell it, you got capital gains to pay. Doesn't matter what you bought it at, it should be at the date of death value. Okay? I think those were all the questions you guys had asked, covered somewhere within the session. Is there any other ones you'd like today?
If our notebooks are more than 5 years old, do they need to be updated to cover that stuff you've added since?
If the notebook is over 5 years old or updated, you need to do it to, can I answer selfishly?
Sure.
The ones from 5 years ago did not say that.
They're different color too.
They're also black. I did buy the firm back, and it's now Reberg Lomberg. It is Reberg, and it was Reberg and Albertson. Mark, if you knew Mark, by the way, he's now, I believe, in Texas. His cancer went into remission. It did come back. They did not have any drugs for it. And what happened was the type of cancer he had should have killed him the first time around. And you take drugs for 5 years, then you have to go off or it becomes septic. So they tried to figure out what to do. They called the manufacturer, who happened to be in Oregon, Said, by the way, we have a problem. We have someone who's lived to 5 years. They're about 6.5. The cancer's back. And the guy goes, wait a minute, what? You have someone who lived more than 5 years? Because he got it in his early 50s, you usually get it in your 70s, and it's a death sentence. But he got it so early. So they made a new drug for him.
Wow.
Put it back in remission again, but he did retire. He's down there. He got bucked off a horse and broke his back, but he lived through that too. He's got 9 lives. Amazing guy. But no, there's not a requirement. Anytime you come see us, if you're coming for a review, bring your notebook. Because if you do need changes, we'll put in the new stuff, take out the old. And anybody who comes in with an old notebook, we always swap them out. Do you have to? No. Do you want to? Then come on, bring your notebook upstairs. Because we will swap them out. We have no problem doing that. It's just, it's not required. And there's no charge for that.
There's no, but if there's additional things in the newer ones.
Yep, the things to do when a death occurs is now 4 pages instead of, some have 2, some have one was 1 page. They haven't done much updating lately. So it really just depends on you, but yes, I can also tell you that I have clients who will email into the team and say, Ryan mentioned the last 6 inserts and the attachments in there. They'll send you just the sheets. They'll email you the sheets or mail them to you. So just put them in there yourself, put the new ones in. So we have people that do that also. So it's up to you. We do them all. Other questions? Yes, I thought there was one over here.
I'm not quite sure how to ask it. It has to do with the state tax threshold.
Mm-hmm.
It's 2.2 million apiece.
Yes.
But in order to take advantage of that, you have to die the tax at the same time?
No.
Or is it like,
If we both, as a husband and wife, have 2.2 million exemption, and how do we make sure we take advantage of both of them? Do we have to die at the same time? Well, the answer actually is yes, that will help. But most people don't schedule it. But proper estate planning, you can say, this is the honey, I love you, but will. Where, honey, I love you, but when I die, I'll go this way. Honey, I love you, but when I die, I'm gonna put mine in trust for you, because I know you've got a list of who you're gonna marry. And I'm okay with you giving your stuff away, but not mine. Well, what that does is the portion that goes into an irrevocable testamentary trust for you is protected up to the limit of 2.2 on the state and 13.61. 13,610,000 for the federal. Okay, so doing proper estate planning can also protect that to get you up to the 4.4.
but if you had wills, it would not.
I love you, will. You can do a marital trust will. A will can put those same provisions in it that a trust does. That was one of the misnomers, that in order to do estate tax planning, you got to do a trust. That came about in the mid-'80s to the early 2000s from an organization out of California that not only got kicked out of the state, attorneys got disbarred, because if you're a longtime Seattleite, you saw their ad in the paper every week. You want to avoid estate taxes? You want to avoid probate? Come to our seminar, and you need a trust. It's a trust mill. They then didn't put anything in it, so when you died, you still went through probate. Okay, that is effective. And so, but what you can do in a will is still do those same protections. So it's a choice again.
I'll trust you on that.
Thank you. Other questions? Okay, I want to thank you for being here. The ladies are here. We have 3 amazing attorneys. We did just hire our 4th. She graduated from Seattle University last Sunday. And so she'll be sitting for the bar in a month and a half, and hopefully by the fall she'll begin the training to be our 4th attorney. Neat person. Amber's really good. But if you are interested in doing a checkup or an initial